Hey folks, James Abrenio coming to you from Abrenio Law, your Northern Virginia personal injury and criminal defense law firm. In this video, I'm going to answer a question I get a lot. James, what is a de novo appeal? I was charged with a crime. I went to trial in the General District Court, and now people are talking to me about a de novo appeal, and I want to know what it is. Well, in Virginia law, de novo appeal is a very important concept, particularly if you're facing a criminal charge. Whether or not you're facing a DUI, a domestic assault charge or a simple assault charge, theft, or other misdemeanor charge. Typically speaking, these cases are brought initially in the lower court, whether or not it's the General District Court or the Juvenile and Domestic Relations Court. And there's other videos that I've done about the difference between General District and Juvenile and Domestic Relations Court. But if you're an adult facing a charge in one of the district courts, a de novo appeal is important because what it means is if things don't go well in the General District Court, you go to trial, you don't like what happened, perhaps the judge convicted you when they thought that they shouldn't, or perhaps they gave you a harsher sentence than you thought was fair, you have a right to a de novo appeal up to the circuit court. That essentially means under Virginia law that the conviction itself is erased. It's as if it did not happen. You essentially get a second bite at the apple when you go upstairs to the circuit court. Now, the difference between the district court and the circuit court, I tell a lot of people, think about it like the difference between Judge Judy that you see on TV versus what you see in the movies, O.J. Simpson trial. In district court, you get more of a Judge Judy type feel. You have one judge that makes the decision. When you go to your de novo appeal up to circuit court, that's where you can get a jury and you have opening statements and a lot more comprehensive trial activities than you would see a lot of times in the General District or Juvenile and Domestic Relations Court. Now, the other thing to remember in Virginia, if you're convicted of your charge in the General District Court and you're looking for your de novo appeal, or in the Juvenile and Domestic Relations Court and you're looking for your de novo appeal, under the law, under Virginia code, you only have 10 days to note your appeal. That's 10 business days. It's not 10, that's 10 days, calendar days, not business days. That doesn't mean you can wait and hopefully get extra days because of weekends and things like that. I always tell people, if you're going to appeal it as soon as you can. You never want to be running to the clerk's office last minute, and then all of a sudden what you've done is you've blown your appeal because let's say traffic is running too late or you miscounted days. Typically speaking, when I'm representing individuals in the General District Court or the Juvenile and Domestic Relations Court, and especially situations where we're looking at trial is a likelihood, I'm talking to my clients about the de novo appeal because, look, things go wrong in trials. That's inherent in any trial, in any courtroom across the country. Sometimes judges get things wrong. Sometimes evidence comes in that shouldn't have, but because of some weird circumstance, it was allowed in. Sometimes things happen. So when I'm going to trial with my clients here in Virginia in the district courts, I'm letting them know before we go to trial, hey, if things don't go well, we're going to note our appeal de novo to the circuit court. After we've had our trial, even if things do go well, unless there's an outright acquittal, I'm always telling my client as well, look, you still have a right to a de novo appeal up to the circuit court. There, you'll get another bite at the apple. You essentially get to try the case again, and you get a second shot. Now, when I do say de novo, one of the things that sometimes is overlooked, while the trial is essentially a start over, there are instances where things that happen in the district court can be used in the circuit court. For instance, let's say I have a court reporter there. I've gotten them to take down testimony. I've then got that transcript for the circuit court, and then I'm cross-examining the same witness and they change their testimony. Well, just because it's a de novo appeal doesn't mean that all of a sudden what's been testified to under oath just gets ignored. So there are instances where I can use that for my benefit. So in many instances, if I'm trying my client's case in district court, I will get a court reporter just to be careful if people start trying to change their story. The other thing that you need to be aware about, that being said, is if you choose to waive your Fifth Amendment right not to incriminate yourself in a criminal trial. You choose to testify. If that testimony is heard by witnesses, it's possible that could be used against you as well. So there may be instances where I'm feeling that it's a high likelihood that we're going to be appealing the case, where I, if I'm your counsel, may, given the circumstances, say to you, look, don't testify in the district court. We'll save that for the circuit court for whatever strategic reason. So, of course, that's not a broad recommendation. It's going to be depending on the facts of the case, depending on the witnesses and the judges and all those kinds of things that are happening. But that's kind of a discussion that may be had. So if you have any other questions about de novo appeals, make sure to reach out to us. You can reach out to us at www.abreniolaw.com. You can also give me a call, 703-570-4180. You can also check out our criminal defense practice page, where we've got a lot of interesting and hopefully useful information. And hopefully you found this information useful. That being said, if you're looking at a trial here in Virginia, if you're thinking you're going to have to go to trial or you're charged with a crime, we always do recommend you talk to an attorney. Don't just rely on information you see on a website or a YouTube video. You need to talk to an attorney that knows what they're doing, that can give you advice on your specific case. You're not required to, but as far as I'm concerned, most attorneys will do free consultations, at least the ones that I'm aware of. I think it's worth your time and effort. Criminal charges are life-changing events, potentially, so invest the time and money as well if that's something that you're able to do. So again, if you have any questions, let us know. If you have other questions that you want me to do a video about too, also reach out. I'm always trying to add new information to our website. So thanks a lot. Wish you the best.